This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant or expert witness, an author and producer of these videos. Today I'd like to talk about some of the grounds that are available to people who are insured for finding a tort of bad faith occurred. First, let's talk about unexplained delays in communication. When an insured asks a question of his or her insurer, an answer is expected. An insurer should respond to all inquiries promptly and in no event later than 15 calendar days after receiving the inquiry. If an insured submits a proof of loss to which the insurer has agreed and asks, "When can I expect to be paid?" the insurer should respond with specificity, "Immediately." Most policies and state regulations require payment within 30 calendar days of agreement to the proof of loss. If the question is ignored and payment is not made after the insurer agreed to the proof of loss, the insurer is breaching the contract, and if without good cause, the covenant of good faith and fair dealing. Often bad faith is merely the difference between courtesy and lack of courtesy. An insurance company will not be allowed to deny coverage where all the relevant facts were known to the insurer at the outset, but it unreasonably delayed in asserting a basis for disclaiming coverage. An unexplained delay of 2 months can be found to be unreasonable in disclaiming coverage. When the insurer waited an even longer amount of time, with an unexplained delay of approximately 1 year before mentioning 2 new reasons for disclaimer, a court would find and did find that the insurer's actions were unreasonable as a matter of law. This was stated in 2 New York decisions, Allstate versus Gross and Mendoza versus American Country Insurance Company. An insurer's unexplained delay of more than 2 years in denying coverage was found to be unreasonable as a matter of law by the New York appellate courts in Hartford versus County of Nassau and in Ward versus Corbally, Gartland, and Rapalea. Policyholders can also act slothfully. For example, in a case where there was almost a year of unexplained delay, plaintiff provided some of the necessary information but still omitted a statement of facts and police reports. Thereafter, a general adjuster retained by the insurer fared little better. Although the plaintiff did provide a written estimate of what it would cost to repair the damaged furniture that was the subject of his claim, he still did not provide documentation needed by the insurer. The insurance adjuster knows better than an insured what is needed to prove a claim. It's his profession or her profession. They deal with claims every day, while insureds seldom, if ever, see a claim, and so it's a first-time thing for them. If, for example, the adjuster fails to ask for a proof of loss or documentation to support a claim or sworn testimony of the insured at examination under oath until months after the loss, the delay in the request can upset the insured and lead to charges of breach of the contract and the tort of bad faith. Failure to demand the proof of loss within the time prescribed when coupled with other acts calculated to lead the insured to believe that the proof need not be furnished within the time prescribed by the policy, is often sufficient to show an implied waiver. The conduct of the insurer throughout the negotiations can show inconsistency with the contention that the insured failed to promptly submit a proof of loss. Consider, of all people, the Knights of the Ku Klux Klan versus Fidelity and Deposit Insurance Company of Maryland, a Georgia decision from 1933. An assignment of the claim to an adjuster who does not have settlement authority by the insurer can also cause difficulties. Some insurers keep tight control of their adjusters. Each level of management has limited authority to settle claims. If the person who meets with the insured has no authority and must work his or her way through multiple layers of bureaucracy, delays that upset the insured become inevitable. If the insurance adjuster has adequate authority to settle with the insured or claimant without delay, that claim will not evolve into a bad faith case. In West Virginia, the Supreme Court, in a case called Shamblin versus Nationwide Mutual in 1990, held that Nationwide Insurance Company did not act as a reasonable, prudent insurance company because it did not have an adjuster at trial with settlement authority or an adjuster with settlement authority available at all times to talk to the plaintiff and plaintiff's counsel during trial. Settlement authority generally refers to an agent's ability to accept an offer of settlement that binds the principal up to and including a certain amount of money. A common misconception is that an insurance company's loss reserves are the same as settlement authority. They are not. The main purpose of a loss reserve is to comply with statutory requirements to maintain sufficient money to pay claims and to reflect as accurately as possible the insured's potential liability. It does not automatically authorize a settlement at that figure. When a trial court ordered the parties to attend mediation and required the presence of a representative of the insurance carriers with full settlement authority, and explained that noncompliance with the order could result in sanctions, an unsuccessful mediation requested sanctions were granted because the insurer's representative appeared only by telephone in a case called Dollar Tree versus Aids, a 2014 case out of Alabama. The failure of an insurer with potential insurance coverage, including an excess insurer, to have a representative attend court-ordered appellate mediation in person with full settlement authority will result in it being sanctioned by a California court for not complying with local rules. And those sanctions can also result in a bad faith tort claim, resulting in both compensatory and punitive damages in excess of the amount of claim. Refusing to pay when liability is clear will always cause a problem for an insurance company, and if, as in Grunberg versus the Superior Court, the insurer refused to pay a claim because it disliked the insured and thought but could not prove that he is a criminal, the insurer was found to have breached the covenant. There is no reason, once liability becomes clear under the policy, for an insurer to refuse to pay a claim. An insurer's actions that deviated from the standard of care for a reasonable insurance company in a similar position with clear liability, reasonable liability, clear coverage, an offer to settle, and a failure to achieve settlement was within the reasonable expectation of an insurance professional handling the claim in the state of Florida for any other carrier in similar situations. And they found responsibility on the part of the insurer in a case called Baranowski versus Geico, a Florida District Court case in 2019. Delays in settlement that damage the insured's goodwill can also bring about a tort claim. The covenant of good faith and fair dealing, although implied in every contract of insurance, still requires that the insurer not breach the promises made by the policy, and where the insurer holds up payment of undisputed claims pending resolution of disputed claims, the insurer can be in violation of the tort. Insurers should understand when handling a claim by a business person that a business has more to do than resolve an insurance claim. The insurer should not deal with the minutiae of the claim process if it is detrimental to the business of the insurer, and therefore the failure of the insurer to settle the claims of the insured's customers while waiting to settle with the insured, two separate parts of a policy's coverage. The insurer found that it did not consider the damage it caused to the insured's goodwill. Good faith requires consideration of the insured's rights and obligations, even if it means handling claims creatively rather than strictly following the policy wording. Delay alone will rarely serve as the sole basis for a lack of a good faith claim, because a finding of lack of good faith rests on a totality of the circumstances, and an insurer's procrastination, without more, might rarely be egregious enough for a jury to find a lack of good faith. Where the defendant insurer failed to respond to plaintiff's letter within 60 days as mandated by statute, the insurer's delay can serve as the sole basis for a lack of good faith claim, because its delay did extend beyond the statutory time period. Refusal to pay a claim where coverage is in dispute is another allegation that can support a claim for violation of the covenant of good faith and fair dealing. And therefore an insurer must carefully consider all facts as they relate to the policy language and the applicable law before it decides to deny a claim. For example, when a passenger was injured in an automobile because a gun with a hair trigger discharged when the vehicle hit a bump, the insurer needed to consider that two policies of insurance may cover the loss: the auto liability policy and a homeowner's policy. The homeowner's policy excludes coverage for losses that occur in an automobile, and the automobile policy excludes coverage for losses resulting from acts not involved in the operation or use of the automobile. The two insurers could both refuse to defend or indemnify the insured. One or both could be liable under their contracts of insurance. When two insurers find themselves in a situation where one of the two may provide coverage, but for the existence of the other insurer, must be careful to protect the rights of the insured. If both deny coverage, the insured who paid for the protection will have nothing. Both will be sued for breach of their respective contracts of insurance and for bad faith. When two insurers are faced with such a situation, they should never leave the insured with no coverage, but should enter into an agreement to protect the insured and agree to work out which insurer is obligated to pay defense costs and indemnity in a later action for declaratory relief or in a binding arbitration. Consider what happened in State Farm versus Partridge, where both insurers were found to have provided coverage because the auto was operated negligently and therefore coverage was applicable under the auto coverage, and the insured was negligent in filing down a hair trigger on his weapon, which was not related to operation of the auto, and the homeowner's insurer was required to indemnify the insured as well. This video was adapted from my book, Zalma on Insurance Claims, Part 106, Second Edition, which is available as a Kindle book and a paperback from Amazon.com. If you found this video to be of use to you or of interest, please forward it to your colleagues. It's free. And please subscribe to my Rumble channel and my YouTube channel, as well as to my blog, so that you can learn about future blog postings and videos. Thank you for your attention.